Yes, Mr. Chaudhary. Positive to go.
My lord, item number 21. Na?
21. And for the
Just a moment.
My lord, 17,
22,
1 minute.
21, my lord.
21, huh? That fight between brothers of different mothers.
Brothers of different mothers.
Brothers of
Yes, Mr. Chaudhary, what is your ground here?
Round, my lord, mainly
Three witnesses.
one is my lord juvenile.
Who?
And my lord, petitioner.
I don't find that plea being taken before the trial court.
Trial court, it was not taken. We have taken before High Court.
That is why the matriculation certificate is there.
That we have taken, my lord. And
But otherwise, the three victims, they are basically the eyewitnesses.
yeah,
Minor inconsistencies are there.
some inconsistency. And my
Where
lord,
the police came, two were taken. What happened to Nobiz Ali?
Obi, my lord, he was more
Found in
hard-
the, what do you call that?
Akir was there.
Akas,
Nabi was
Zakir,
there.
and why do you want an adjournment?
Yesterday, I could not prepare the case, my lord. My specs got broken, my lord.
Okay. On a prayer made, Mr. B.M. Chaudhary, learned counsel for the for the petitioners, prays that the matter be accommodated, matter be adjourned today, and be taken up on
Any day next week, my lord, either Tuesday or Thursday.
Can I can
Linapari, 4 on 4/11/2025. Prayer is not objected to by Mr. P.K. Dekka, learned counsel for the inform, as well as the additional public prosecutor. Also, accordingly, registry to list this matter again on 4/11/2025.
Your lordship.
I'll forget.
I may appeal, lordship. I beg to. I am my lord. For
Whatever mentions are there, give it to her. If there is urgency, tomorrow make a mention, otherwise give it to her.
item number 15, as per my instruction, the already died in the year.
Anup Sharma. Interesting case. Matter went up to the Supreme Court also in one line with regard to the possession.
15. It is a check.
15, Anup Sharma. Check bounce manner, Mahindra.
I don't know. my lord.
15.
Earlier, SK Borkotegis was there.
Okay. Mr. D.K. Nath, learned counsel for the petitioner, submits that during the present pendency of the present proceedings, the petitioner herein, Anup Sharma, has passed on when?
Take that I don't know, my lord.
Passed on.
2022.
In the year
2022.
2022, in the year 2022. Accordingly, he prays that the matter be closed as having become abated. Full stop. Prayer is full stop. None appears for the respondent. In view of the above submission of Mr. D.K. Nath, the present revision petition stands closed on being abated.
May I please, Your Lordship? Lordship, I beg to mention item number 24, Your Lordship. Like matter, Your Lordship. Your Lordship,
That failed.
that failed, Your Lordship. The only part that failed was that we were willing to pay in parts. Now we are willing to pay in full, Your
Get,
Time may be given.
no, get the respondent. We'll settle it up today itself. What is that?
Want to sit once before settling, before.
Let the respondent be here for the accused.
Yes, Your Lordship. Petitioner, Your Lordship. I am willing to say it on record, Your Lordship.
Okay. Okay, we'll record your thing. You are Mr. T. Chetri, learned counsel for the petitioner. For the petitioner, submits that the petitioner has instructed him to submit before this court that the check amount would be that the It's, how much is the amount?
5 lakhs.
Ah,
5
The,
lakhs is already paid.
the compensation as awarded by the Learned Trial Court would be paid by the petitioner to the respondent number 2 within on or before. Ajit, please tell me. 14/11/2025. Registry to list this matter again on 18/11/2025.
5 lakhs was already paid.
Whatever it is. What it
Much obliged. Your Honor.
Anybody for item number 23? Okay. The rules are there.
Yes.
Today's list. You are appearing for? Last date, I think it had come up for orders or something. I did not go into the matter. I'll not take it up. Both parties, the petitioner is very closely known. The other party is also known. 23. List this matter before any other bench without me. Come after vacations only. I can't pass a fixed date. That's why. You just make a mention, we'll accommodate you. Wherever the court is. For eye operation, how can we start pressurizing Mr. Das to be here? We cannot and we will not.
Have to postpone.
No. That is more important. Yeah, go and get it done. 6 and 7.
But that day, both, this
Lord.
Interim order passed. Oh, how can I? Registrate, in view of the fact that there is an interim order operating in the matter, registrate to list this matter again tomorrow before the appropriate bench, Kaliyadidia, tomorrow morning. Interim order is still today.
I will manage the interim order.
Tomorrow we are getting it listed so that you can get the interim order. Yeah, Monday. 3/9, 3/11. 3/11. We will give you probation. That's all. Nothing more.
whether these persons are still living.
Can't help it. But Mr.
Yes, that's.
S. Das Learned. You are appearing for, you are the
Both the
amicus
matter-
curiae.
amicus.
Both the matters, no?
Both the matter.
Mr. S. Das Learned Counsel for the petitioner as amicus curiae for the petitioner. Item number 6 what likhiba. Also heard Mr. B. Sharma. We have heard him, we'll just put it. Mr. B. Sharma, learned special PP. Special PP forest appearing for the respondent number. For the respondent. Also, the present revision petition has been instituted, assailing the judgment dated 13/12/2010 passed by the additional session judge bracketed FTC, Bongaigaon, in criminal appeal being CA number 05 bracketed I down bracket over oblique 2010, upholding the conviction of the petitioners herein by the wide judgment dated 29/12/2019 passed by the Subdivisional Judicial Magistrate bracketed M. Bizni in CR case number 132/2007, convicting the petitioners herein under section 24/25/35/41 of the Assam Forest Regulation 1891. So, I've heard the learned counsel for the parties and perused the materials available on. Full stop, Enagari. The prosecution story in brief is that on 6/7/2007, Sri Amarendra Nath, Forester 1, you take your seat, Mr. Das. Forester Grade 1 of Manas National Park lodged a complaint before the SDJM Bizni inter alia, stating therein that on 30/6/2007 at about 7 p.m. while he and his colleagues were on patrol duty at number 9 Bishnupur area of Manas National Park, they had apprehended 9 numbers of persons carrying logs in 6 numbers of bullock carts from inside the Manas National Park. So, it was further stated in the, it is further projected that the bullock carts along with the 7 numbers of Khakan, KHAKAN logs valued at around rupees 10,777 were seized from the possession of the persons so apprehended. Also, the said complaint on being lodged came to be registered as CR case number 132/07, and on taking cognizance of the offence involved, summons came to be issued to the accused, including the present petitioners. Also, during the trial, the prosecution examined 5 witnesses. Thereafter, the accused, including the petitioners, herein, were examined under section 313. Also, on conclusion of the trial, the learned trial court wide judgment dated 29/12/2009 on appreciating the evidences coming on record was pleased to convict the accused, including the petitioners herein, under section 24/25/35/41 of the Assam Forest Regulation 1991 and sentence them accordingly. Subpar, being aggrieved by both the cases emanate from the same, being aggrieved by the conviction. Petitioners ko esuna upor these petitioners have not gone on appeal. Solely Abdul Kashaw, that's the petitioners instituted, petitioners assailed their conviction by way of instituting an appeal, being criminal appeal number 05/1/2010 before the court of the learned session judge Bongaigaon. The said case was transferred to the court of the additional session judge FTC Bongaigaon for disposal. First up, the appellate court, on an appreciation of the evidences coming on record as well as appreciating the grounds taken in the appeal, was pleased wide judgment dated 13/12/2010 to dismiss the said appeal, upholding the conviction of the petitioners herein. Also, it is to be noted herein that the appeal as filed by the petitioners was considered along with another appeal filed by one Abul Qasim, who was also an accused before the trial court. in trial court, appeal being criminal appeal number 3 bracketed 01/2010 filed by one Abdul Qasim, who was also an accused before the learned trial court. Also, being aggrieved, the appellants, petitioners have instituted the present proceeding. I've heard the learned counsel for the parties and perused the materials available on record. The learned trial court, upon appreciating the evidences coming on record, was pleased to draw the following conclusions. Page 27. A to A. Para 16 to, Also, on drawing the above conclusions, the learned trial court proceeded to convict the petitioners herein under section 24/25/35/41 of the Assam Forest Regulation 1891 and sentenced them as follows. B to B, page 32. Also, the petitioners herein, being aggrieved, instituted an appeal before the learned sessions judge, before the court of the learned sessions judge, Bongaigaon. Also, the learned session, the matter on being transferred to the court of the additional session judge bracketed FTC Bongaigaon, the same was taken up for disposal. Also, the learned trial court, the learned appellate court, upon considering appreciating the evidences coming on record, as well as considering the grounds of appeal taken in the matter by the petitioners herein, was pleased by judgment dated 13/12/2010 to dismiss the said appeal. The learned trial court in the said appeal had drawn the following conclusions. 43 C2, court has perused the conclusions drawn by the learned trial court as well as by the learned appellate court and finds that the conclusions so drawn have been drawn basing on a due and proper examination of the evidence, due and proper appreciation of the evidences coming on record. So no infirmity is found with regard to the conclusions drawn in the matter by the learned trial court as well as by the learned appellate court. Accordingly, this court is of the considered view that the conviction of the appellants herein under section 24, 25, 35, 41 AFR 1891 would not mandate any interference. Having drawn the said conclusions, this court notices that the offense alleged against the petitioners herein was so committed on 30/6/2007. Also, more than 18 years have lapsed since the date of commission of the offense by the petitioners herein. It has not been brought to the notice of this court that the petitioners herein were involved in commission of a similar nature of offense either prior to 30/6/2007 and or thereafter. Also, this court also notices that the petitioners herein were litigating in the matter initially before the appellate or before the trial court, thereafter before the appellate court, and presently before the before this court in the present revision petition, for the last around 18 years. Also, in view of the above position, this court is of the considered view that the petitioners herein, in considering the long lapse of time occasioning in the matter, this court is of the considered view that the petitioners herein are entitled to be extended with the benefit under the provisions of the Probation of Offenders Act 1958. তাৰপিছত accordingly jail নহয় যিটো আৰু before the ইয়াত ফাইন নাই দেই ফাইন আছে বাদ দিয়া Sub-divisional judicial magistrate M. Fine to diba has not interfered with the sentence of fine to diba. Did not interfere with the 1 month from today. Yes. P. Sharma, we have recorded our next case to our Khali petitioner. As on yes. Disposal.
Highly obliged.
Please, your lordship, kindly pass over the matter.
Also, yes.
Evidence of all the witness, except my lord, PW, my lord, 2, my lord, But TIP was-
That is a normal thing. TIP will not be required because he was immediately caught, bought. What is the purpose of a TIP now?
one has seen, my lord, he has come out from that house, my lord.
He has been seen by the by Robiram Boro.
Yeah, Robinam Boro, my lord, cross-examination, my lord.
Huh.
We have read on last occasion, my lord.
Hmm. Five years, second last. Yes. Read it. Read it for him, Mr. Goswami. পঞ্চাশ মিটাৰ 60 মিটাৰ
But it's not been recorded in the
In the judgment, it is not recorded. What is there?
hope by that, my lord, that ঘৰত যাই চাব নোৱাৰিলো মানে
And when he went there, he did not see.
he did not see, my lord.
But in his chief, he says that when he reached there, he saw.
My lord, dark night.
Yes. ক'ব নোৱাৰো Now, if that is intact, then where is his statement? Then if you compare it with PW2, PW3 is not been considered because he was not a listed witness in the charge sheet. So he was excluded. Now, if you consider PW2's evidence, the boy came in, he saw her, she saw her, and then he rushed out. He went away. She then moved to the place where the husband was there, informed him. And then they came back, and thereafter the people had brought. So there was a time when the boy was not there. But the husband, but Rupala Boro does not support this part. Rupala Boro came immediately, did not see the boy. She was there only. The moving out of the PW2 is not established. And the husband also, Mahendra Roy, PW1.
My lord,
He
their
she
wife
says,
came
I
to-
heard the sound and I rushed down.
Wife came to him, that
No, not proved.
is what he has submitted.
No. If you see, just read that PW1 also.
One, my lord, that is.
PW1 said he heard the sure and he rushed. That she going there was said by PW3. In the cross you say. PW1.
ৰখি আছিলো মোৰ ঘ-
Ojit Boro, Kamer Boro and all those. Goi khobor diye here.
খবৰ দিয়ে।
Goi khobor diye. Now you see. Asami.
মই সুধো মোৰ এটা কাম আহি মই আছা দেখা নাই
Aye.
মোৰ
See the timing. Rupala Boro is there. She does not say about the wife moving out of the house. In the chief, he says, sure huni ahilu. But in the cross, he says that no, my wife came there. I came back with around 4 or 5 people, but I did not find the accused in the house. Now see the evidence of the brother. Immediately on hearing the sound, he came and he
W5
Right. He saw the accused moving out of the house. He did not apprehend her. But none of the witnesses say that the Robiram Boro was also there. PW1 does not say, take the name of Robiram Boro. He takes a name of 4 or 5 people, but Robiram Boro is not one of them. Maybe it seems to be a mistaken idea. And where the boy was apprehended from? The boy who apprehended him? No evidence.
public we have
Public, who is that
we
public?
have apprehended my lord.
Who is that public? That is not there. So whether this is the boy, she might have just said also. A doubt naturally arises. He
There are
could not.
some persons
This boy, from the evidence of PW1, was not known to her. Name was not known to her.
Him she has given.
She has given subsequently. When the man was brought and showed,
She identified.
later she came to know the name of the accused as Avendra Boro from Bina Boro. Gone. But even for this to come in, there has to be something more.
Statement of the
Victim's statement is there. We have seen it, but
yes identified. That is one part, madam.
no, she identified the boy. Fleeting in the lamplight, she saw a fleeting image of the boy.
I only state my evidence of it, my lord.
What she says is fine, but who apprehended the accused? Who brought them? From where? Whether it was near the house or somewhere else, or somebody from the road who was a odd man out, not a man of the village, was brought. Or it might even be that the boy moved out. The Raviram Boros saw. So the whole thing, otherwise it was consensual. There is a doubt created. So after 13 years, we'll not send him to jail on such. Not probation, we are acquitting him. But Mr. G. Alam, learned counsel for the petitioner, also heard Mr. MP Goswami, learned counsel, learned additional public prosecutor appearing for the state. The present revision petition has been, a present appeal petition has been instituted, assailing the judgment dated 9/5/2013 passed by the learned session judge Bongaigaon in sessions case number 18 bracketed BGN bracket over particular oblique 2013, convicting the appellant herein under section 354 IPC and sentencing him to undergo simple imprisonment for 1 year and also to pay a fine of ₹1,000. In default, simple imprisonment for further 2 months. So, the prosecution case in brief is that informant Uttam Boro had lodged an FIR with the in charge, North Bongaigaon outpost under Bongaigaon police station, stating inter alia therein that on 7/1/2013 at around 11 p.m. while he was at his cycle stand in front of Raj Tilak Theatre, in his absence, the appellant herein had entered into his house and attempted to commit rape on his wife Bina Boro. It was further stated in the FIR that when his wife had raised alarm, some neighboring people came to his house and caught hold of the accused. Also, it was further disclosed in the FIR that the matter being informed to the police, the police from North Bongaigaon outpost had come and taken the accused along with him. On receipt of the said FIR, police registered Bongaigaon PS case number 9/2013 under section 376/511 IPC. Also, on conclusion of the investigation, police laid a charge against the appellant herein under section 376/511 IPC. Also, the case being exclusively triable by the Court of Sessions, the case came to be committed to the Court of the Learned Session Judge Bongaigaon. So, the trial court, on appreciating the materials coming on record, proceeded to frame a charge under section 376/511 IPC. So the charge on being read over and explained to the petitioner appellant herein, he having pleaded not guilty and claimed to be tried, a trial ensued. The learned trial court on conclusion of the during the trial, the prosecution examined 6 witnesses. Thereafter, the appellant herein was examined under section 313 CRPC. So on conclusion of the trial, the learned trial court, on appreciating the evidences coming on record, proceeded to acquit the appellant herein from the charge so framed against him under section 376/511 IPC. So, however, the evidences coming on record having established a charge under section having brought on record commission of an offence by the appellant herein under section 354 IPC, the learned trial court, wide judgment dated 9/5/2013, proceeded to convict the petition appellant herein under section 354 IPC and sentenced him as noticed herein above. Also, being aggrieved, the petitioner has instituted the present proceedings. Mr. G. Alam, learned counsel for the appellant, at the after taking this court through the depositions of the prosecution witnesses, has submitted that there exist discrepancies with regard to the presence or with regard to the narration of facts leading to the apprehension of the petitioner, of the appellant herein by the public, by the villagers. So he submits that the victim had, during her deposition, victim had deposed in the trial as PW2, and in her deposition she had deposed that she had seen the accused in the light of the lamp and thereafter raised an alarm, and the accused had left the place. She further deposed that she had gone to inform the matter to her husband, and the people of the village and members of the theatre committee had apprehended the accused and brought him to the residence of the informant. He further submits that PW5 Robiram Boro, who is the brother of the informant, had deposed that on hearing the shout of PW2, he had rushed to the house of his brother and therein had seen the accused coming out of the house of his brother. So, he submits that he further submits that PW1, the informant, during his course had stated that after the incident, his wife had come to the place where he was running his cycle stand, which is around 50 to 60 meters away from his house, and informed him of the incident. He further deposed that Mr. Alam further submits that the PW1 had deposed that on receipt of information from his wife, he, along with 5-6 persons, had come to his house. However, he did not find the accused in the house. Mr. Alam submits that neither the PW5 nor the PW1 or PW2 had stated anything about the presence of PW5 at the place of occurrence. Also, he submits that the PW4 Rupala Boro, who is a neighbor, had deposed during the trial that she, on hearing the shout of Bina Boro, had rushed to her house, and Bina Boro had stated about the incident to her. PW4 further deposed that some people of the theatre committee had come and had brought the accused to the house of the informant. Mr. Alam submits that PW4 has not deposed with regard to the PW2 moving out of the house after the incident to inform PW1 about the same. Subpara. Mr. Alam submits that the persons who had purportedly apprehended the appellant hearing after the incident were not, submit that no witness was adduced from the persons who had purportedly apprehended the petition appellant hearing after the incident on the fateful night. Also, he submits that the present case is a case of mistaken identity and the prosecution has failed to establish the identity of the appellant hearing, has failed to establish that the appellant hearing was the aggressor in the matter. Also, in view of the above submissions, in the above premises, Mr. Alam submits that the impugned judgment and order dated so-and-so passed by the learned trial court would mandate an interference from this court. Anything more? This will do. Mr. MP Goswami, learned counsel for the learned additional public prosecutor, after taking this court through the evidences brought on record during the trial, has submitted that minor inconsistencies existing in the matter would not be fatal. Minor contradictions are found in the deposition of the prosecution witnesses. However, he submits that the same is not fatal to the prosecution's case, inasmuch as the fact that the appellant hearing was the aggressor was established beyond a reasonable doubt from the evidence of from the deposition of the victim, that is PW2. He further submits that the other witnesses had also identified the accused to be the aggressor in the matter on he being identified by PW2. Mr. Goswami, learned additional public prosecutor, has submitted that no material was brought on record by the appellant hearing to highlight any animosity existing between the appellant and the family members of the existing between the appellant and the informant and or his family members. Accordingly, Mr. Goswami submits that in view of the evidences coming on record, the charge under section 354 IPC law against the petitioner hearing, appellant hearing, stood established, and accordingly the impugned judgment dated 9/5/2013 would not mandate any interference from this. Right? I've heard the learned counsel for the parties and also peruse the materials coming on record. Also, for the purpose of appreciating the conclusions reached in the matter by the learned trial court, as well as the submissions made before this court in the present matter by the learned counsel for the parties, this court would notice the deposition of the prosecution witnesses. PW1, Uttam Boro, the informant, during his examination in chief, had deposed that he was at the relevant point of time at his cycle stand near the theatre premises of Raj Tilak theatre. He further deposed that on hearing a shout from his wife, he had rushed to his house, and on being asked, his wife had stated that the accused entered into his house and attempted to commit rape on her. And when she had raised alarm, the accused left the house and he was restrained by the people of their village. He further deposed that when the accused was brought before his wife, she identified him to be the one who had attempted to commit rape on her. Also, during his cross, a different version was deposed by the PW1, wherein he deposed that at the relevant point of time, he was standing in his bicycle stand, and after the incident, his wife had come there and informed him about the incident. He deposed that he was at a distance of around 50 meters from his house. PW1 during his cross further deposed that on receipt of the information from his wife, he had come along with 5 to 6 persons and had named the persons. He further deposed that on reaching his house, he had not found the accused therein. PW2 is the victim. PW2 Bina Boro is the victim, and in her deposition, she had deposed that on 7/1/2013 at around 11 p.m. while she was sleeping in a house along with her child, in absence of her husband, who was at the relevant point of time at his cycle stand, which he started during the theatre, the accused entered into their house by pushing the door and had come to her bed and kissed her. She also deposed that the accused had removed her clothes and also put out his own clothes and attempted to rape her. PW2 deposed that at first she had thought the man to be her husband. However, subsequently she noticed the accused in the light of the lamp and raised an alarm, during which the accused left the place. She further deposed that she had then gone out to inform the matter to her husband and had then informed the matter to her husband. She also deposed that the people of the village and the members of the theatre committee had brought the accused to her residence. And on being asked, she had identified the accused to be the person who had attempted to commit rape upon her. She further deposed that the police had thereafter come and taken the accused, and her husband had lodged the FIR. Also, PW4 Rupala Boro had deposed in her evidence that Rupala Boro, a neighbor, during her evidence in her deposition had deposed that while she was sleeping in her house at the time of the incident, she had heard the shout of Bina Boro and had rushed to the house of the victim. And on being asked, the victim had stated that someone had said one person kissed her and had broken her leg bangles. This is why I'm saying, Mr. Goswami, he does not know. Bangles, and that is not said by her, but the person kissed her, not Manuezon. So, she further deposed that after some time, people of the theatre came. Theatre committee brought the accused, and later on, she came to know that the name of the accused was Arvindra Ovari from Bina Boro. During her cross, she deposed that she stayed in the same compound as that of the victim, and having heard the shout, she had immediately gone to the house. Also, PW5 Robiram Boro deposed in his evidence that Robiram Boro, brother, PW5 Robiram Boro, brother of the informant, deposed that At the relevant point of time, he was outside the theater, and on hearing the shout of the wife of his brother, he had immediately rushed there and had found the accused coming out from the house of his brother. So he further deposed that on being asked, his wife stated that the accused had entered into their house. So the police, he further deposed that in the meantime, police had come and taken the accused along with them. A perusal of Fusop. PW3 Mohendra Roy. The deposition of PW3 Mohendra Roy was not considered by the learned trial court inasmuch as he was not cited as a witness in the charge sheet and the defense had taken an objection with regard to the deposition made by him in the matter. Also, a perusal of the evidence adduced in the matter by PW1, PW2, PW4 and PW5 brings to the forefront that while PW4 and PW5, while PW5 had immediately rushed to the house of the informant and had seen the accused coming out from his house, PW4, who also had deposed of having immediately rushed to the house of the informant on hearing the shout of the PW2, had not deposed about the presence of the accused, either in the house or nearby. PW1 had deposed that after the incident, his wife had come and informed him about the incident, which was also corroborated by PW2. However, PW4, who had come to the house of the informant, had not corroborated such statement made by PW1 and PW2. Accordingly, also, having noticed the set position with regard to the evidences adduced by the prosecution witnesses, this court notices that the prosecution had failed to adduce evidence of any of the persons who had apprehended the accused. So it is not apparent from the materials, from the evidences coming on record as to the place from where the accused was apprehended. So the deposition of PW4, Rupala Boro, also brings to the forefront that the petitioner here, that the victim PW2 did not know the name of the appellant at the time immediately after the incident when she had narrated the fact to PW4. Also, the incident having taken place on 7/1/2013, it is to be noted that the same being during the winters would be dark. Also, accordingly, a doubt arises with regard to the fact as to whether it was the appellant herein who had trespassed into the house of the informant and had tried to commit rape upon the PW2. Also, the materials coming on record having not demonstrated commission of rape by the commission of rape upon the appellant herein, the Rennet trial court had acquitted the present appellant from the charge framed against him under section 376 IPC. However, by holding that it was the appellant herein who had entered into the house of the petitioner, of the informant on 7/1/2013 at around 11 p.m. and attempted to commit rape upon the petitioner, upon the victim PW2, the learned trial court proceeded to convict the petitioner, the appellant herein under section 354 and sentence him as noticed herein above. The conclusions drawn by the learned by this court with regard to the depositions, with regard to the evidences coming on record, having brought to the forefront a doubt with regard to the fact as to whether it was actually the appellant herein who had on the fateful day entered into the house of the informant and tried to commit rape upon the victim PW2, the inconsistencies as contradictions as existing in the depositions of the prosecution witnesses not having been clarified and it further not having been brought on record as to from where the accused was so arrested, was so apprehended, and the reason as to why a suspicion had arisen with regard to the appellant herein by the persons who had actually apprehended him not being brought on record and the contradictions not being clarified, this court is of the considered view that the doubt as arising in the matter would have to be answered in favor of the appellant herein, and accordingly the conviction of the appellant under section 354 IPC would not be maintainable. For so, the appellant is entitled to the benefit of doubt, and accordingly he is acquitted of the charge under section 354 IPC. For so, in view of the above discussion, the present appeal, in view of the above discussion, the impugned judgment dated 9/5/2013 passed by the learned session judge Bongaigaon in sessions case number 18 bracketed BG and stands set aside. The appellant herein is set at liberty. His bail bond stands discharged. With the above observations and direction with the and the present appeal stands allowed. Registry to send down along with the
Flash, my lord. I'll do.
Bora is in the Yes, Mr. Bora. Where is the surface? Easy.
This is an appeal against acquittal, my lord. In an NIA case, my lord. The learned trial court, rather, my lord, in this case, put the burden on the complainant. Otherwise, would have been otherwise, my lord. Complainant cases that the respondent issued a check. The respondent with his team has stayed in the lodge of the complainant. Accordingly, after staying, he has issued the check, my lord, along with the other thing, and for that purpose issued the check that has bounced, my lord, check of rupees 39,000, and accordingly we issued the notice. He has received the notice. Thereafter, my lord, they appeared and contested the case, my lord. During the evidence, we have exhibited all the.
But the signature of the
He has not.
accused is not there.
Signature is there, my lord.
His signature is not there. Accused signature is not there in the bills.
Signature is there, my lord.
The bills. Not in the bills, Mr. Bora.
Oh, no, bills is not in the bills. Not in
The signature is in the check.
only the checks, man. Our case is the
Now
only check.
the written memo of the check. If you just
it is for insufficiency of fund.
no, it's not that. Just check up that. Insufficient fund. Okay, insufficient fund.
So basically, my lord, the learned trial court.
The case of the the accused was, or the defense was,
Yes.
that he had not issued this check.
Exactly, my lord, that
He
has
said
not
that
stayed.
that liability was not accepted by him.
Yes, liability was not that he has not denied that he has not issued the check. There's no stop payment prior to that, my lord. There's no FIR prior to that, that he has lost the check. Or there's anything that he issued the checks only for the purpose of some
Security.
security purposes. It's not his.
No,
case.
that is not his case.
His case is simply, my lord, simple denial, my lord. And our case is that, yes, couldn't have placed the bills and anything. So the learned trial court has taken the reverse burden on us. Otherwise, in the 18 of the Act and the 139 also, the burden lies on the accused, my lord, to rebut the presumption. Presumption was in my favor, my lord. But rather, the learned trial court, based on one judgment of the Supreme Court, has acquitted the, but you can see the paragraph 9 of the judgment, my lord. That is the judgment, but that judgment has subsequently been overruled by the Supreme Court, my lord. That I'll place on record, my lord, that particular judgment, my lord. That's not the correct proposition of law, my lord. Subsequent judgment by 3 judges, my lord, has overruled that particular judgment, my lord.
Now, the fact is that there was a check issued that is not denied. Why that was issued is not brought on record, whether it's for some other purpose or not. You had demonstrated before the court, because liability was to be brought on. You had demonstrated that this person and his team on 2 occasions had stayed in your premises, and the check is in your name,
I know.
in your name. But you're some green or something,
Green.
Reed Lodge.
Yes,
It's not in the name of the lodge.
yes.
It's in the name of the person. And your defense is that you don't have an account in the name of the lodge. Now, be that as it may, the check was issued in the name of Bipin Gogoi. And he deposited it, got bounced. There is no material adduced by the defense as to why the check was given to you. In that view of the matter, basing on the materials on record, it was permissible to him to to rebut that presumption under the NI Act by saying that by preponderance of probability,
Yes,
by
yes,
bringing in some material,
Some material, my lord. Not beyond reasonable doubt, only the preponderance of.
preponderance of probability.
But his case is that he has not denied that he has not issued the check, or there's no liability against this in my lord. They have said that yes, my liability against that particular farm, but that's not his case, my lord.
No.
He said that I don't have even liability. He denied.
And
our-
the handwriting in the check, the signatures have also not been disputed. Yes,
In-
Mr. Snows.
My lord, learned senior
That is gone.
one, my lord. Now, here the complaint, some amount was paid in cash. Now, in his 313 statement, says that I did not issue the check,
But this was not pursued with the cross-examination.
my lord. And in fact, PW2 was the bank official, was examined by the complainant side, and from his account, this check was his denial.
Will not be.
Certain statement, my lord, is contradicted by PW2, my lord. And another thing which I have seen, my lord, with the learned trial court, the view which has been taken by the learned act, that this check was not issued in the name of Green Lodge, but in the name of Gogoi.
But there is no explanation to it.
That's at best a proprietorship. So proprietor, they are not too distinct. Then he gives an
He
explanation.
has given an explanation also.
That I don't have an account in the name of, that is possible also, my lord. But the fact that the check was issued in his name, the presumption will have to be drawn that this check was issued to him in
Legally,
debt or liability. Now, for rebutting that presumption, he has two options. Either he will adduce evidence
that he was not there on the day.
not there, because he denies. In his 313, he denies that. Or he could have relied upon the cross complainant to rebut the presumption.
But in the cross-examination, he has not brought any such material on record.
He only puts the question on the complainant, to the complainant, use the bills,
Original. bills.
original bills. And those bills which photocopies and all were there, but they were not exhibited, they did carry his signature. What he was trying to project was that I had not lodged, and that is why my signatures are not there in the bills, and you have not even exhibited the bills. So on that aspect, this has been, they have at least objected to their case, my lord. Now, the one thing which your lordship will examine here is that he has not offered an explanation as to why he issued the check. Imagining, my lord, that he had not, that is his case, that he had not stayed in that lodge, then why did he issue the check? Because there's nothing to show that there was any previous transactions between them, or that this check was issued for the purpose of securing some liabilities. So there must have been some reason as to why the check ended up with the complainant.
There is nothing.
That is not there, my lord. So to say that even on the
So
standard
that presumption is to be drawn in favor of the
complainant,
complainant and not in favor of the accused as drawn by the
trial
learned trial.
So trial court says that this the standard is of preponderance of A. But at the same time, trial court says that the presumption is only not in respect of a legally enforceable debt or liability, but in respect of any debt or liability. Because of that level of presumption, coupled with the fact that the complainant could not produce any documents to prove the state of the accused in the lodge, so the presumption stands rebutted. But now Rangappa says that this presumption, that the finding in Janardhan Bhatt is incorrect to that aspect. That this presumption is indeed that of a legally enforceable debt or liability. But the standard of rebutting remains the same, of preponderance of probability. Now, if the presumption is that of a enforceable debt or liability, then he has to rebut. But if the view taken by the trial court is deemed to be correct, that it is not that of a legally enforceable debt or liability, the complainant will have to prove that there was a subsisting debt or liability. Since that is not the correct proposition, so the complainant is not encumbered with the burden of proving that there was a legally enforceable
He will have to raise a dispute
dispute.
by some cogent material, then only the onus would be
Shift.
Then again, it will shift to me.
to me, and then he will have to come up. But here, although in the complaint, the annexures were there, that was not exhibited, maybe because they were Xerox copies. But all said and done, the fact that the questioning as to why the check landed up with Mr. Bora was never.
So that even on the standard of probabilizing a defense, he has, my respectful submission. Only
Okay,
because
now
of the-
we'll have to, in this view of the matter, we'll have to interfere with this order. and-
Perhaps your lordship will examine being an appeal against an acquittal. That
Whether we can convert that to, How?
Appeal against acquittal, my lord. Can convert it.
Going by the standard, my lord, that ordinarily when an appeal is to be interfered with by the appellate court, my lord, and judgment of acquittal, because that presumption of innocence gets reinforced by the judgment of.
That case, my lord, actual dispute, my lord, but actual dispute. Text is clear, only on the law point, my lord. On a trial court, lordship kindly see,
but thing is that let us remove para 9. If we
Yeah.
remove para 9 also,
yes,
the other factors are there that he had questioned that did not go into all those things on a wrong presumption the court has proceeded. Now, would it be a case for remand?
and my lord, because remand the same, my lord, the same material will be there, my lord. Fresh evidence.
So if I have to convict him, then to go. Then I'll have to convict him.
Issues,
Factual issues we don't
Not
find
there.
here.
like as also cannot. These are the facts and these are the evidence. So remand
Will not work out. Then what penalty can I issue here? What compensation?
Same amount, my lord.
Same amount of the check. In default, imprisonment.
Your Lordship perhaps can say case 13 case.
Hmm.
So the punishment is imprisonment or fine, which may exceed to twice the amount.
Or both.
So my respectful submission, if the imprisonment part and fine commensurate to the
Fine, what would be commensurating according to you?
one thing is
13
it's a
years.
very old case, my lord.
No. We'll also have to consider the money value.
39
Which 39,000 is not what is 39,000 in
Okay.
2013. It's much more. So how do we go about with that?
end of the day, your lordship will not be able to exceed 8,000. That
I
will be
mean,
the
I
maximum.
cannot go.
Yes.
I'll have to be between somewhere.
39 and 78, my lord. One, my lord,
Its maximum is twice the amount.
Twice the amount.
twice the amount.
Okay. Where is that judgment that which
Yes.
overrules?
There are 26, my lord.
Rangappa, I think, has been further considered with approval in a judgment authored by Chandrachud. 3 judges.
Opposition has started from Rangappa.
Rangappa.
Continued, my lord.
Even in that 2025 thing also, this is there. Okay. Anything more, Mr.? Heard the Learned Counsel for the parties at length. Heard Mr. A.M. Bora, Learned Senior Counsel, assisted by Mr. M.S. Hussain, Learned Counsel for the petitioner. Appellant also heard Mr.
Yes, Nawaz.
S. Nawaz, Learned Amicus Curiae, appearing for the respondent. Hearing concluded, judgment. Hearing concluded, registry to list this matter. Hearing remains inconclusive. Registry to list this matter again on 6/11/2025. I'll pass the order. You need not be here. I'll just read it once. Thank you, Mr. Nawaz. Yes.
Last date, my lord.
We'll pass the order. তো এইখিনি আছে নহয়? Right there. Sorry. I'm just putting it like this. I'll pass the order on 11th. Some backlog. 11. As agreed to by the Learning Council for the parties, registry to list this matter again on 11/11/2025 for further hearing. I'll pass the orders on that day.
Husband, my lord,
On the point,
on defense witness or rebuttal.
the only thing is your cross-examination. That is creating the whole problem.
Right.
Duty of Mr. Yeah. But unfortunately, that's the evidence on record.
Which my lord, DW, my lord.
Not required. He can always rely on that's the proposition of law, preponderance of probability. That is enough for him. We'll see.
At this matter.
I have heard it. We'll allow it. Because the evidence is not, medical evidence is that it is coma. When he went into coma, whether he was,
So as because lordship, the head injury lordship,
head injury, whether that's why, the head injury leading to the death
lordship,
and
as a result of the head injury.
injury. When that coma set in,
Was due to the head injury it was coma.
I know that. But whether he was in a position, Ms. Beckham, whether he was in a position to speak coherently,
Was lordship in the police station he
he
was.
was.
He was.
Where is
Then-
that evidence?
Then
Why the IO did not examine him at that relevant point of time? Because he was there for some time. I know that.
Thank you.
GD
Yeah,
entry is not on the basis of the victim. Mr. Sharma is there.
uh,
Mr. Sharma, GD entry is not on the basis of the disclosure made by the victim.
Yes, my lord.
is
GD
by the
entry
people.
was made on my lord 4.
Court.
4. In
Then if
the
GD
morning.
entry was made, why the accused who was why the victim who was there in the police station not examined?
Yes. That is the my lord.
Lacuna,
drawback of
because
this
what
case.
happens is whether he was in a position to speak, no other witness said that he deposed. The people who had taken him have not been examined.
But my lord, you'll find it, my lord, though it is hostile, my lord, though he is later on, my lord, is deposed that my lord, the disease reported that he was assaulted
But
by the
you declared him
yes.
hostile. And there was another doctor in between. The
Yes.
doctor who deposed as PW2, before him, that he is a postmortem examination. Before him, another doctor had put a stitch.
Put a stitch.
Whether the person was in a position to speak, because injury is severe. Whether he was in a position to speak, what was the nature of the injury? Nothing. When was he taken to the
Yes.
hospital? Nothing is there.
And my lord, lordship will find my lord, the IO's deposition, my lord. He clearly said that my lord chronology.
Hmm.
When he informed GD entry was made, he moved to the place of occurrence.
No,
And-
the deposition is to the extent that the victim had not said. Some people who brought him had said. Now, what was the condition of the victim at that point of time?
The doctor, my lord, in his report and his
Coma.
said that, or say comma, and he said that when postmortem was done, my lord, already there is a stitch.
Who made that stitch? That
That-
doctor is not examined. Four-9 hospitalized, 5-9 morning dead.
Thereafter, my lord, on 5, my lord, when my lord Azhar was FIR was lodged and registered under section 341 and 325 and
Then
307.
302 was added.
Later on, my lord, 30 added under after the permission from the honorable.
That too maybe. Hmm.
Deposition of PW 5.
PW5 is the friend, Ungad Biswas. The thing is, PW, medical evidence is PW.
Two, my lord, doctor.
Was dead due to coma as a result of head injury sustained, which was the learned trial court omitted this part. The judgment, this part is omitted. It only says the opinion that injury is highlighted. That was due to antemortal homicidal head injury, but the coma part is omitted. I think this much doubt is there whether the two can be. Dying declaration, fine, but dying declaration also has to be with the material that the person was in a position to speak coherently. And if he can speak to two persons, why not the IO?
The place of occurrence, my lord, was some deposition, my lord, is there, my lord, that police took them.
Police took them.
Police took them. So, my lord,
No, the public took them to the police
police.
station.
So, my lord, police, my lord, after some time, police got the, my lord, disease.
No, GD entry was immediately made.
And my lord, he was sitting in the Thana.
Anna, why that was not, if he can say this
Yes.
to this two, why not the IO? I think that
Lapse.
a doubt.
That lapse is there, man.
But Mr. T.J. Mohanto, Learned Senior Counsel, assisted by Mr. P. You are Mr.
I'm A. Burwa, but that day Mr. T. Gogoi is.
T. Gogoi, assisted by Mr. T. Gogoi, Learned Counsel for the petition. Also heard Mr. B. Sharma, Learned Additional Public Prosecutor. Facts ki nahi likhi was. We are quitting. But of course, the present appeal has been instituted. Assailing the judgment dated 21/2/2014 passed by the Court of the Learned Session Judge Tinsukia in Sessions Case number 97 /T of 2012. convicting the appellant herein under section 304 part 2 IPC and sentencing him to undergo rigorous imprisonment for 3 years. The prosecution story in brief is that an ejaha was lodged at Guijan Police Outpost on 4/9/2011 by one Nityananda Bhar, inter alia stating therein that on 4/9/2011 at around 9 a.m., while his brother ejaha was lost by Nityananda Bhar, inter alia stating therein that on 4/9/2011 at around 9 a.m., while his brother Ashok Bra had gone to the market with vegetables, the appellant herein had accosted him and hit him on his head with a hammer, causing grievous injury. Also, on receipt of the said FIR, GD entry number 59 dated 4/9/2011 was registered and the FIR was forwarded to the Tinsukia police station for its registration. Also, the said FIR was registered as Tinsukia PS case number 4554/2011 under section 341/325/30 IPC. Also, the victim Ashok Bhar having passed away subsequently, section 302 was added after the permission for the same was granted by the learned court. Also, on conclusion of the investigation, the police police laid a charge sheet against the present appellant under section 341/302 IPC. Also, the learned trial court, upon appreciating the evidences coming on, materials coming on record, was framed a charge under section 302/341 IPC against the appellant herein, and the same on being read over and explained to him, he having pleaded not guilty and claimed to be tried, a trial ensued. During the trial, the prosecution examined 7 witnesses, and thereafter the appellant herein was examined under section 313 CRPC. Also, the learned trial court, upon conclusion of the trial, on appreciating the evidences coming on record, was pleased by judgment dated 21/2/2014 to convict the appellant herein, comma, under section 304 part 2 and sentenced him to undergo rigorous imprisonment for 3 years. Being aggrieved, the appellant has instituted the present appeal. So, Mr. T.J. Monto, learned counsel for the petitioner, at the outset has submitted that the conviction of the appellant herein is based on the depositions of PW4, Nityananda Bhar, the informant, and PW5, Angad Biswas. By taking this court through the evidences through the deposition of PW4 and PW5, Mr. Monto has submitted that the said deposition had brought to the forefront that the deceased, on being asked by the said witnesses, had stated that he was hit on his head with a hammer by the appellant herein. Mr. Monto has referred to the deposition of the doctor conducting the postmortem examination of the deceased, who had deposed during the trial as PW2. Mr. Monto has submitted that the opinion rendered by the PW2 is to the effect that the death of the deceased was due to coma as a result of head injury sustained, which was ante-mortem in nature, caused by blunt force and homicidal in nature. Also, Mr. Monto has submitted that the deposition of PW2 had also revealed that the deceased before his death was treated by a doctor and he had also undergone a surgery. However, the prosecution had not examined the doctor who had treated the victim, deceased, after the injury was sustained by him and prior to his death. Also, Mr. Monto, by referring to the deposition of PW4 and 5, has submitted that the statement made before them by the deceased was held by the learned trial court to be a dying declaration, and by placing reliance on the same, the appellant herein was convicted. Mr. Monto has submitted that the said witnesses and or the other witnesses adduced by the prosecution, including the investigating officer, had not adduced any evidence with regard to the mental condition of the deceased to make a dying declaration. He further submits that the evidences coming on record does not reveal that has not brought on record the condition of the deceased at the time when he was available in the police station on being taken there by the people who had gathered at the place wherein the deceased was purportedly assaulted by the appellant herein. He further submits that the appellant here, the deceased being in the police station, a GD entry already being made on information being furnished by the people who had, by the persons who had taken the victim and the accused to the police station, no clarification has been placed on record by the prosecution as to why the examination of the deceased was not carried out by the investigating officer at the relevant point of time. Mr. Mohanto submits that the above position raises a situation wherein it can be said that the deceased, on account of the injury sustained by him, was not in a position to speak coherently and also thereby not make a statement with regard to the person who had assaulted him. Mr. Monto has further submitted that there exist two 161 statements recorded of the informant. In the first statement, so recorded on 5/9/2011, there is no statement made with regard to the dying declaration purportedly made before him by the victim. It is in the second one statement recorded on 6/9/2011, after the death of the victim, the informant had improved upon his earlier statement and had brought on record the dying declaration purportedly made before him by the police. Mr. Monta has further submitted that the evidences coming on record reveal that the deceased and the accused were brought to the police station by persons who had gathered at the purported site wherein the incident had occasioned. However, none of the said persons were examined as prosecution witnesses in the matter. So, he submits that matter. So, he accordingly submits that as to the the examination of the said prosecution witness, said persons who had brought the deceased and the accused to the appellant herein to the police station would have revealed the fact as to whether the deceased was at the relevant point of time when he was in the police station fit to make a statement with regard to the injuries sustained by him. Anything more?
My lord, that is it.
313.
Prosecution, that means the Lana trial court relied on the material which are not placed before the.
Mr. Monta, by referring to the examination of the appellant herein under section 313, has submitted that although the trial court had relied upon the purported dying declaration made by the deceased before PW4 and PW5, a question in this connection was not put to the they said issue the petitioner, the appellant herein was not examined on the said issue. Also, in the above premises, Mr. Mont submits that the present appeal is required to be allowed by setting aside the impugned judgment convicting the appellant herein under section 304 part 2 IPC. Per contra, Mr. B. Sharma, Learned Counsel for Learned Additional Public Prosecutor, has submitted that A perusal of the evidences adduced by PW4 and PW5 would highlight that they were consistent, that submits that a perusal of the evidence adduced by deposition of PW4 would reveal that he had deposed that on being asked, the deceased had told him that the appellant herein had hit him on his head with a hammer. Mr. Sharma submits that the said deposition is corroborated by the deposition made by PW6, who had also deposed in similar lines. He submits that the deposition of PW4 and PW6 are direct, and the prosecution and the defense having not dislodged the depositions as made by the evidences as adduced by PW4 and PW6, in spite of they being submitted to cross-examination, the said evidence having implicated, the said evidence having, first of all, they said the deceased having passed away soon thereafter, the statement made by the deceased to the PW4 and PW6 incorporated by them in their deposition is to be deemed to be a dying declaration, and accordingly, the reliance placed thereon by the trial court cannot be said to be erroneous. Mr. Mr. Sharma has further submitted that although PW4 and PW6 are not eyewitnesses, however, their deposition brings to the forefront that their deposition clearly implicates the appellant herein, and accordingly, the conviction of the appellant herein under Section 304, Part 2 would not mandate any interference. Mr. Sharma further submits that the evidence the evidence adduced by PW4 and PW5 being reliable and trustworthy, the dying declaration coming on record of the deceased through them would not call for any further corroboration. And the same can be a basis for convicting the appellant herein. Accordingly, he submits that the judgment and order, judgment dated so and so 21/2/2014 passed by the learned trial court would not mandate any interference. Also, the learned have heard the learned counsel for the parties and also perused the materials. The learned trial court, upon appreciating the evidences coming on record, including the medical evidence adduced by PW2, had proceeded to draw the following conclusions. Page 13, para 15 and 16. Also, a perusal of the said conclusions drawn by the learned trial court would reveal that the learned trial court had relied upon the deposition of PW4 and PW5, who had deposed that on they reaching the police station had found their brother therein, and upon asking him, had found the deceased, their brother deceased therein, and on asking him, found the victim therein, and on asking him, he had deposed that the appellant herein had hit him on his head with a hammer. Also, the statement as made by the deceased before the PW4 and PW5 was taken as a dying declaration of the deceased Ashok Bhar. The learned trial court further concluded that the deposition made by PW4 and PW5 being found to be truthful, reliable, and trustworthy, and the dying declaration so brought on record being corroborated by the medical evidence with regard to the nature of the injuries, held that the same can be the basis for convicting the petitioner herein. The learned trial court thereafter noticing that the incident had occasioned pursuant to a quarrel, proceeded to further conclude that the appellant herein cannot be fastened with an intention to cause death. Accordingly, the learned trial court proceeded to convict the appellant herein under section 304 part 2 and sentenced him as noticed herein. Yeah, allowing the appeal. The rest conclusions I'll. Any Mari?
That is very difficult. But sometimes, my lord, all cases are listed. First, we have inquired whether he is alive or not. In two
Well,
cases, my lord, I have seen.
They are gone. I've also got it.
But here he is alive, my lord, he is there.
Any, thank you. Yes.
Item number 12, the person expired.
15 to 24.
22.
And this Pawan Kumar Srivastava? Madam, you get your instruction. Huh? No, you also get your instructions. Whether he is alive. Item number 12 word likha. Prasad Kumar Chanda is no more. He is the man with the IOC, ONGC,
Vice Chairman.
Vice Chairman. Heard Mr.
MS Hussain.
Huh? MS? But you're not there in the case. Embora. We'll write Mr. Embora's name. Mr. M. Hussain, Learned Counsel, assisting Mr. M. Bora, A. M. Bora, Learned Senior Counsel, on instructions has submitted that the appellant herein, or during the pendency of the present proceedings, had passed on, on 15/2/2022. Accordingly, he submits that the present appeal stands accordingly, he submits that the present appeal may be closed on being abated. Prayer is not objected to by the Learned Standing Council, CBI. So, in view of the above, the present appeal stands closed on being abated. Then we will consider 12. Here 12.
13, item
13, sorry. We'll consider 13 then. Here 13. What is that? Who is appearing? Mr. Kotogi is appearing. Where is he? He is in a position to do the matter today. Okay, 2 p.m. 2 p.m. Yes, Mr. Bora. Short, sweet judgment. 3 pages, reasonings, done. 3,08,808. What is your defense?
at the time of opening of the account.
That is, why did you give the check? There is a liability. He says that there is a liability of 3,080. And this was not cross-examination. Show me whether you cross-examined on this point.
But in the cross examination, the admitted that was not read.
The decision of the Supreme Court is, even if it's a security check, you say that you will pay the amount, it's not paid, that will be a liability.
All but suggestions were denied, Lordship. সত্য নহয় যে মোৰ ভাই ইন্ট্রোডিউসার আছিল
ভাইটি আছে।
আমি বেংকত একাউন্ট খোলা সময়ত 4টা ব্ল্যাঙ্ক চেক রাখো।
So he denied that. And you have also not said anything with regard to the liability.
Yes, that's true, Lordship.
Then
Reduce any evidence also. All
313 is not required, but the cross you could have utilized the cross. In the cross
Yes.
also there is nothing. So you got enough relief. Heard Mr. A. Burwa, Learned Counsel for the petition. Also heard Ms. You're there. Okay. Also heard Ms. A.N. Begum, Learned Additional Public Prosecutor, appearing for the respondent number 1. None has entered appearance for the respondent number 2. The present revision petition has been instituted, assailing the judgment and order dated 4/7/2014 passed by the Learned Session Judge Gulaghat in criminal appeal number 14/2012, dismissing the same and thereby upholding the judgment dated 11/4/2012 passed by the Learned Judicial Magistrate First Class Golaghat in CR case number 2562/2009, convicting the accused under convicting the petitioner herein under section 138 NI Act and sentencing him to undergo simple imprisonment for 1 year and to pay compensation of rupees 3,08,808 only in default of payment of compensations to undergo simple imprisonment for 6 months. Yes, if you undertake to pay, I'll omit the if you that, but you will have to make a statement to that effect. You'll make a statement. Then we will allow him. How long?
But with the,
Within what time will you make the deposit? Within 6 months from today. Then we are not going into the other issues. Also, the prosecution case in brief is that the respondent herein had instituted a complaint petition and therein had stated that the petitioner herein used to purchase fish on credit from it. The complainant was projected to be involved in wholesale business of fish at Golaghat market. On account of the transactions existing made between the complainant and the petitioner herein, an amount of rupees 3,08,808 was found to be payable to the complainant by the petitioner herein. It is projected that in towards satisfaction of the said debt, the petitioner herein had issued a check bearing number 865690 dated 27/2009 for an amount of rupees 3,08,808 drawn on Vijaya Bank, Golaghat branch. So it is further projected in the said complaint that the said check on being presented for clearance, was dishonored by the bank due to insufficient funds in the account of the petitioner herein. Also, on receipt of the said intimation from the bank, the complainant issued a legal notice to the respondent herein on 7/8/2009 demanding payment of the check amount within 15 days from the date of receipt of the same. The accused, the petitioner herein having failed to make the said petitioner herein who had received the said demand notice on 8/8/2009 having failed to make the payment, the complaint came to be instituted. Also, the said complaint, the said complaint was registered as CR case number 2562/2009. The learned trial court, upon considering conclusion of the trial on appreciating the evidences coming on record, was pleased by judgment dated 11/4/2012 to convict the appellant herein, the petitioner herein under section 138 of the NI Act and direct and sentence the appellant to undergo simple imprisonment for 1 year for the offence punishable under section 138 of the Negotiable Instruments Act. So the learned trial court further directed for payment of an compensation to the complainant, that is the respondent herein, of an amount of rupees 3,08,808 by the petitioner herein, and in default of payment of the compensation, directed that the petitioner herein would undergo further simple imprisonment for a term of 6 months. The amount of compensation on recovery was from the accused was directed to be given to the respondent herein as compensation under section 357 CRPC. Subpara. The petitioner herein being aggrieved by his conviction under section 138 CRPC, 138 NI Act, and also the direction by the Learned Trial Court for payment of compensation to the respondent herein, assail the same by way of instituting a appeal being criminal appeal number 14/2012 before the court of the learned session judge Gulagan. The learned session judge Gulagan, upon appreciating the evidences coming on record in the trial and also considering the grounds taken by the appellant herein, was pleased to dismiss the said appeal, thereby upholding the conviction of the appellant as well as the direction for payment of compensation to the respondent herein. Subpara. Being aggrieved, the petitioner has instituted the. Shall we record your submission? First up, the materials. First up, this court has carefully perused the. First up, Malay. Mr. A. Borua, Learned Counsel for the petitioner, after attempt has submitted that the petitioner undertakes to make the payment of compensation as directed by the Learned Trial Court, wide judgment dated 11/4/2012 to the respondent in installments starting from 1/11 from 15/11/2025, and the same and the amount involved would be paid in full on or before 15 December, January, May, 15/5/2025, 26, sorry. Go back, 26, full stop. He submits that the said undertaking would be complied in its true sense, and the installments would be deposited before the Learned Trial Court without fail on the 15th of every month starting from 15/11/2025 till 15/5/2026. What he says, none has appeared for respondent. Also, the appellant herein, the petitioner herein, having undertaken to pay the compensation as awarded by the Learned Trial Court, wide its judgment dated 11/4/2012, this court is of the considered view that the present revision petition would not be required to be further adjudicated, and by noticing the undertaking made by the Learned Counsel for the petitioner on instructions, made by the petitioner through the Learned Counsel of the petitioner, through the Learned Counsel of the petitioner. This court directs that in the event the appellant without fail deposits the installments of the compensation amount of rupees 3,08,808 plus a further amount of rupees 1 lakh, totaling 4 lakh. We'll have to compensate that 1,50,000 quid. 1,50,000. 1,50,000. Money is of 2009. 1,50,000 totaling. Kiman? A total Goidiasan 3,08,808 plus 1,50,000. In installments. Starting from 15/11/2025, every month on 15th of every month thereafter till 15/5/2025, the penalty, the sentencing of imprisonment as ordered by the learned trial court shall be kept in abeyance. So, subpara. In the event the appellant fails to make the payments as directed herein above of the amount of rupees total arrival lihidiba, words or lihidiba, 4 lakhs ki manogona, 4,58,808 in installments with effect from 15/11/2025 till 15/5/2025, comma. The order, present order, keeping the imprisonment in, keeping the punishment of imprisonment in keeping the punishment of imprisonment awarded by the learned trial court in abeyance would stand vacated, and the appellant would be required to undergo imprisonment for 1 year for the offence punishable under Section 138 NI Act, as well as for a further period of 6 months for the non-payment, for the default occasioning in non-payment of the compensation amount. Also, with the above observations and directions, the present revision petition stands disposed of. Or Likha, registry to send down the records of the case to the learned CJM, Chief Judicial Magistrate, Golaghat, Ushal of Chief Judicial Magistrate, Golaghat, along with a copy of the present order for information and necessary action. With the with the above. Yeah.
16.
Hold on. 2014. Service is not complete on sole responsibility.
Revision petition. So, first 800, you have got no objection.
Because it was-
1,500,
It was expertise, I agreed to pay.
you agreed. Enhancement 127, enhancement 500.
500.
Nothing. We are convinced there is nothing here.
Your lordship.
Are you paying 1,500 regularly?
yes, my lord.
That is nothing.
But, in
Don't.
the initial stage, 500. 1,000 was, 800 was given. And I was paying-
1,500.
I was paying.
2,500, you show me the ground. Why I should not accept the order of the learned trial?
My humble submission before lordship. Actually, there is no marriage at all.
That is not,
forceful
that,
very-
that is,
was
that is
was
already,
the
that
thing.
you, that is
Another-
already
another
gone
thing
by.
is This, your lordship.
Mr.
is-
Mr. Sharif, we would have accepted that plea of yours, Sheikh, Mr. Sheikh, we would have accepted that plea of yours if the challenge was to the first maintenance order.
Not first maintenance order was expertise order.
Be that as it may, you accepted it.
Yes. I
That is it.
accepted it, but thing is this, my lord, enhancement is not proper. Because, my lord, they prayed something, but exceed of the payment is it. But it is state 127 feet. My income doubled after the first order was passed. And subsequently, my lord, it is given to 2,500. It is
Let us see
given
the order.
three-
Let us see the
three-
order.
More than 3 times, my lord.
Page 40.
Yes, my lord. First, your lordship would be pleased to
This
take.
is not an ex parte order. This is a contested order. This order is a contested order. The impugned order is a contested order.
Order is contested order.
Let us see what
But
material is.
first order of 8,
That you have complied. We are not. That is not under challenge here.
my lord.
Yes. What is the ground? Let's see what are the pleas taken.
But here in the ground, my lord, only thing I want to say, but not taking much time. Only thing is this, my lord, that prayer was made in 27 petition that my income is double after the order of 800 rupees per month made. Now, my lord, if it is double, my lord, it should be 1600. Instead of 1600, it is made 1500. That is the ground your lordship can consider. And your lordship at the time of admission also, I am directed to pay 1500 rupees per.
We gave you enough relief. We gave you enough relief.
But if it is made at 16, my lord, it will be proper, because that is the 127 petition. But my income doubled. My income doubled, my lord, in the meantime. In that case, my lord,
Let us see the judgment. What are the reasoning? You have 2 children. One is married.
No, my lord, I have 2 children. That is not the case. Case is this, my lord, she was earlier married.
You know, she had 2 married, one Torah Pali. Oh, okay.
Probably, and she had 2
2
children.
children. Okay.
They are major. Allegation against me is this, my lord, that I brought her to Guwahati, kept her in Guwahati, and thereafter, by force, I was compelled to marry her.
Once you have not challenged the first order, Mr.
That is there, my
125,
lord.
then
my lord.
we are not.
My lord, my humble submission before your lordship, 800 rupees I have not challenged. Now your lordship will consider the sense of circumstances under 127 CRP. What is the sense of circumstance? What is the petition? Your only thing is this, that it is double. It is double. If it is double, then in that case it will be 60. I'm not saying that nothing will be given to her. And maybe, but it may be double, not the triple one.
And today, what is
Three times.
2,500,
Three times.
Mr.?
Well, your lordship will consider my position. What is my income?
Where is your material with regard to your
Your
income?
lordship will be pleased to see my written statement, my lord.
What is your evidence?
Evidence I have given, my lord, evidence.
Where?
W.
Page.
Yes, my lord, I'm giving. Next are 10. Is 62 to 70. Also aged person, my lord, about 61 years. Eight, my lord, I am not rich. I do not have service.
Your basic case is that she is not my wife.
Lord, as your lordship pointed out, that point will not go. That she was married, it is not valid marriage because I have not challenged this 800 rupees. That point your
You
lordship
still
pointed out.
challenge, you
I do
get that.
agree- I do agree to that because I have not challenged. But my humble
But you can
submission
still
before your
challenge
lordship,
that
your
aspect of the.
lordship would be pleased to see the 127 petition. In the 127 petition, she specifically said, my income doubled. But your lordship, nowadays, 14, it was a case of 14. And now in 2025, 11 years. So my lord, if necessary, she can file again 127. Spiraling of price, etc. But not that.
So spiraling of
what
a
is the petition, my lord?
Mr. Sheikh, you agree that spiraling of the price, inflation is a ground for filing an enhancement application?
Yes.
Yes.
That can be, but that is the thing, my lord. She prayed in 127. 27 that my income is double. Then
No, we forget the income.
800 will be 1600.
Mr.
It is 25.
Mr. Sheikh,
It is
let us
excessive.
forget that, but ground of inflation and price rise. Inflation is price rise.
My lord, but your lordship will not consider as on today.
No, as on that day.
Yes, my lord.
No, I just wanted to know,
Yes, yes.
inflation is a ground for enhancement.
That is the ground, my lord. Taken into 27.
127. That can be
120,
taken.
yeah, that is the ground taken.
Where?
127 petition, my lord.
Okay, that ground can be taken.
That can be taken. I am not denying. But why,
When was the first order passed?
my lord? First order. But marriage was on 2009, in 2010, my lord.
Two 2010, 28/10/2010.
Fourteen, my lord, it is made more than triple, my lord. Only thing is the quantum, my lord. I humbly submit before you, lord. It may be, I am not that interim order was passed in my favor, 15,
1,500.
1,500. It may be 16, my lord.
We'll keep it at 2,000. End of the matter. Heard Mr. M. A. Sheikh, Learned Counsel.
Your lordship, another thing is this, your lordship. Your lordship will consider that if an amount is fixed by your lordship, not payable from my side, if it is a burden on me, my lord, no party will be benefited. Because here what will happen? I will not pay. And if I cannot pay, my lord, I will put to jail. After 1 month, I will be released. Again, there will be.
That is 40.
That is what, my lord, it may be 1600, my lord. Well, any amount below 2,000.
What is the
Below 2,000, my lord. Amount.
what is the
I am conceding to 16.
you discuss with your client, come back at 2.
My lord, it will be difficult to discuss with my client, my lord. It is after 11 years. It is not possible to communicate.
So we fix it up, taking everything, we fix it up at 2,000. And as this court had given 1,500, 500 more.
Here will come, my lord. Hearing date, my lord, it may be at 16. Because, my lord, she prayed for double.
Where is the prayer?
Trial court cannot go beyond.
Where is the prayer? Where is the prayer for
127? Your lordship would be pleased.
page?
127 petition, my lord.
Where page?
Yes, I am giving one. One minute.
I think it is 5,000.
petition under, my lord, 127 CRPC, that is at page 31,
Huh?
is 28 to 31, my lord.
28 to 31. That is 5,000. Not double.
Hence, in the content,
How are you paying the amount to the lady? How are you paying the amount to the respondent? Monthly amount, how are you depositing?
15, my lord.
How? In what
Cash,
manner?
by cash, my lord. By cash. Because, my lord, I do not have service like this, my lord. Otherwise, if I do not deposit, my lord,
He is satisfied with 1,500. He is satisfied with 1,500.
15.
1,500? 1,500?
1,500.
Uh-huh.
He is.
Interim order of this court is of
My lord,
with effect from 36/2014. Do
There
you
will
take
come.
a receipt from her when you pay her 1,500? Are you taking a receipt?
my lord, it is in the record, my lord. in the-
Which record?
For court's record.
You
Court
deposit
will
in the
be a
court.
Deposit in the court. I have
Court.
to pay.
In the court.
But your lordship will consider that huge area amount will come, 11.
Will come. Will naturally
That
come.
benefit has been given by your lordship. I am paying 1,500. 500 per month area will come. It will be about per year 1,000 per 1,000 per year. In that case, $6,000 area will come. So if your lordship consider at
Okay, I'll consider at 2 o'clock.
and another thing is this, my lord. Measure side children. That is my case.
2,000. I'll consider and pass the order.
My lord.
Between 1,800 to 2,000.
My lord, maybe 1,800.
Shall I record your?
Yes.
Okay. I'll record it at 2. 2 o'clock I'll record it.
My lord.
It's 1 o'clock now.
In that case, my lord, my present.
Oh, we'll record it. Likhilo. The present revision petition has been instituted assailing the heard Mr. M.A. Sheikh, learned counsel for the none has entered appearance for the respondent number for the sole respondent. The present interlocutory application has been present criminal revision petition has been instituted assailing the judgment dated 36/2014 passed by the subdivisional judicial magistrate bracketed S. Gwalpara in MCR case number 218/2013 under section 127 CRPC, enhancing the maintenance awarded to the petitioner from rupees 800 to rupees 2,500. Also, with the effect from the date of passing of the order, that is with effect from 36/2004. Also, the present petition being filed before this court on considering the materials available on record was pleased by order dated 11/9/2014 to direct the petitioner herein to pay a monthly allowance of rupees 1,500 per month till disposal of the present proceedings with effect from 36/2014. Mr. M.A. Sheikh, learned counsel for the petitioner, has submitted that the petitioner has been regularly depositing rupees 1,500 per month with the learned trial court, and he has not defaulted on the said account. Mr. Sheikh submits that the present petitioner had disputed the marriage between the parties and had also brought on record before the
Only
learned trial.
paying, my lord, on instruction, my lord. That what may be written.
On instructions as submitted, Liquid. Learned trial court. You are not depositing. Full stop. Vakil Hisham had also brought on record, disputed the marriage, no? Huh? Marriage between the parties, and also had brought on record the fact that the petitioner herein is not having the means to pay the amount, enhanced maintenance amount. Also, the respondent is not represented before this court in the present proceedings. Also, next. Mr. Sheikh has submitted that he submitted that the petitioner undertakes to pay an enhanced amount of rupees 1,800 with effect from 36/2014 to the petitioner, and the areas working out would also be cleared within a period of 2 months from today. The said amount, along with this area amount, along with the enhanced maintenance of rupees 1,800 is undertaken to be deposited before the learned trial court regularly every month, and the area amount would be so deposited within a period of 2 months from today. So,
Months will be short, my lord.
2 months, no, nothing more than that. You have
3
got
months,
enough
my lord.
relief.
3 months, my lord. Well,
This interest is enough. 3 months, 3 months, 3 months. The above order being passed, facing that the present case is a long pending one, and having been passed in absence of the petitioner, petitioner is at liberty on account of the delay on account of the lapse of time occasioning since the passing of the order dated 36/2014 to file appropriate applications for enhancement of the maintenance amount as awarded by this court herein above. So, with the above observations and directions,
trial court, my lord.
fine, wherever under 2127, wherever she files, she can't file it here. She'll have to file there only. The above observation and direction, the above present revision petition stands at this.
One word will be better for the trial court. Otherwise,
I'll modify it. Registry to send down the records of this case to the learned trial court, and the trial court shall monitor the payment of the arrears along with the monthly compensation, enhanced monthly compensation as awarded by this court. I'll just modify this.
Mathogo, sir.
Draft my even. Yes, Mr. Yes, ma'am.
Item 18, my lord.
What happened?
On the last occasion, my lord, the appeal was directed to report.
Yes.
What is about that?
Now we'll have to fix a date. File to some. But Mr. P. Shah, learned counsel appearing for the petitioner. Also heard Mr. M.P. Goswami, learned additional public appearing for the state, and Ms. M.S.B. Soikia, learned counsel appearing for the respondent number 2, representing the granddaughter of the respondent number 2. Also, in terms of the directions passed by this court-wide order dated 22/10/2020, Mr. M.P. Goswami, learned additional public prosecutor, has placed on record a communication dated 29/10/2025 issued from the office of the senior Morigaon, wherein it has been by which the officer in charge, Morigaon Police Station, has been directed to take necessary steps for having the petitioner produced before the medical board. Also, this court-wide order dated 15/9/2025 had passed the following directions. 15/9 to para 2 prade dot mari para 2 prade A2 A. Also, on account of the fact that the petitioner could not be produced before the medical board, his examination was not possible to be carried out on 15/10/2025 as directed by this court. Also, in view of the instructions issued by the Senior Superintendent of Police Morigaon, wide the communication dated 29/10/2025 to the officer in charge, Morigaon PS, this court now requires the production of the petitioner before the medical board by the officer in charge, Morigaon PS, on, give me a date. November, on 19/11/2025. Also, the medical board, in terms of the directions passed by this court-wide order dated 22/7/2024 and 15/9/2025, shall examine the petitioner and furnish before this court on the next date of listing, in a sealed cover, through Mr. D. Upamanyu, learned standing counsel, Health and Family Welfare Department, their report. A report of such examination, the findings of the medical board upon examination of the petitioner hearing. Also, registry to list this matter again on when? On 1/12/2025. 1/12/2025. Also, Mr. M.P. Goswami and Mr. Additional Public Prosecutor and Mr. D. Upamanyu shall forward a downloaded copy of the order to their respective respondents for compliance. Registry to list this matter, लिखी जाए ना, तार ऊपर लिखी बाई तो. Registry to list this matter, तार विशद लिखी बाई. A copy of the communication dated 29/10/2025 is kept on record and marked as X. At least now let's see something will happen. Six about? Oh, 17 no, I think. 16. Yes, have you got the case diary? His statement is recorded.
Recorded.
What is there?
As per the asked them to, my lord, for procuring those house, my lord. For
Is he the owner of the truck
not the owner, but he is the person
person?
take the other house and, my lord, and then
Yes. No, no, no.
uh,
Why will they bring you in? What is the love affair you have with them? Hmm? He will appear every 15 days before the. But Mr. SRA Nasir, learned. That also. Learned counsel for the petitioner also heard MP Goswami, learned additional public. This court-wide order dated 13/10/2025 had, considering the contentions raised by the accused petitioner in the present petition, extended the liberty of pre-arrest bail to the petitioner and required him to appear before the investigating officer and have his statement recorded on or before 24/10/2025. Also, the case diary has been perused and it is found that the petitioner had appeared before the investigating officer and his statement was recorded on 17/10/2025. Also, the materials appearing in the case diary does not disclose that the petitioner has misused the liberty of pre-arrest bail, interim pre-arrest bail as extended to him by this court-wide order dated 13/10/2025. Also, the materials in the case diary further reveals that the petitioner to be involved in the theft of cows, cattle, theft of cattle, and accordingly, Mr. MP Goswami, learned additional public prosecutor, submits that the custodial interrogation would be mandated in the matter. I have perused the contents in the case diary as well as heard the learned counsel for the parties. Full stop. Next. On due consideration of the materials coming on record as well as the disclosures made in the case diary, this court is of the considered view that the custodial interrogation of the petition this stage would not be called for. However, could not be called for. Also, the petitioner not having misused the liberty as extended to him, the liberty of interim pre-arrest bail as extended to him by order dated 13/10/2025 and his statement having also been recorded. This court is of the considered view that the interim bail as granted to the petitioner by order dated 13/10/2025 be made absolute subject to the following conditions. 1. The accused petitioner shall appear before the investigating officer at an interval of 15 days from today. Also, and shall continue to so appear till the investigation in the matter is complete.
all for, my lord.
Also, the petitioner shall also appear before the investigating officer as and when called for the purpose of investigation of the matter. RP sir, yare 2 number 2. Like 3 number 2. Petitioner, accused petitioner shall not indulge in commission of offense similar in nature to the one alleged against him in Moriani Police Station case number 89/2025. Also, next, the petitioner shall not leave the jurisdiction of the court. Court would be G. CGM, Jorhat, Court of the Learned CGM, Jorhat, without prior permission. So, next, etu hoigol, polotaha. Any violation of the conditions set out in the present order would lead to vacation, that lead to cancellation of the pre-arrest bail as granted to the petitioner by this court by the present order. With the above observations and directions, the present bail application stands disposed of.
Deeply obliged.
Please, Your Lordship.
Which paper? You will have to publish again in the vernacular also because it has to go together. Both papers noticed? Okay. The Learned Counsel for the petitioner has submitted that the petitioner would issue fresh notices in 2 dailies, one English and one vernacular, routed through the registry of this court for service of notice upon the respondent number 2 and 3 by way of paper publication. Also, accordingly, the petitioner is permitted to take steps to publish the notice in the English daily, Northeast Times, and in the vernacular daily, Doinik Ahom, within a period of 2 weeks from today by routing the same through the registry of this court. Upon publication of the said notice in the newspapers, the petitioner shall file an affidavit to that effect. Also, registry to list this matter again on Ajikiman Prisoner 24/11/2025. Why? When is he coming back? On 2/12/2025. 2/12/2025. Permitted. Prayer of the petitioner is petitioner is by publishing the notice to news dailies, that is vernacular English, got ordered to us a Silovi. Kiman?
22.
Yes. Hmm? Now the session court has taken a view that he was not heard. What do you have to say on that?
Trial courts.
Yes, show me. No, it may be correct, but he was not heard. Why? Matter was remanded back by the sessions court earlier. He was not heard. And then he instituted this proceeding. So what is the error here? That conclusion you will find page 58. Middle. Record reveals that the set case record was received by the learned ADM on so and so, and no notice was given to the second party in respect of the proceedings. First party, Somoto, appeared and the learned ADM, without giving any opportunity to the second party, had passed the impugn order dated 9/2/2018. Who is for the petitioner?
Reading.
In
Yes, yes, relax and say, ma'am, no rush. Yes. Who? Okay, call Mr. Kadi. We'll.
he's coming.
It was 12 and 13 now. Madam, you have anything with regard to 12? The petitioner has said that he is no longer there. That is abated then. He is alive. Item number 12 kune marise? Huh? Sharma. Upload kuru mana korokso. What is it? Get it. Oh, I have not signed. Okay. Also, আগৰ খিনি থাকক তলত মাৰি দিবা Miss M. Devi Leonard M. Kumari Leonard Retainer Counsel CBI has submitted that the respondents are presently inquiring into the matter as to whether the petitioner has in fact passed away and the verification report shall be submitted before this court before the next date of listing. Also, in view of the above, please inform Mr. Bora also about this. In view of the above, raised to list this matter again on when, ma'am? 10 days. On 12/11/2025. Ekini baki ekini ate ache. Okay. Yes, Mr. 13.
Yes.
He is alive.
Yes. Yes, and my greetings, my Durga Puja, my lord. Most probably is alive. I cannot.
313 he
77 then.
because in the 313
Is he alive?
I have to check it out.
Huh? Also, Ms. M. Kumari, Learned Counsel for the submits that on the next date of listing, she would apprise this court as to whether the present petitioner, present appellant, is surviving or had during the is surviving. First up, accordingly, registry to list this matter again on eketa date did
Same day.
Agor 0 date disu kiman disu?
No,
12.
no, I think he is-
12/11/2020. Madam, same date. Along
Otherwise-
with
Otherwise, married, sir, we have a good case, man. Documents will prove, my lord.
along with criminal appeal number 133/2014. Get the instruction. It is with regard to that land.
Yes, there are two aspects, my lord. One is the rate. The rate saying that is according they have enhanced to 50,000.
And the state government has also supported that the enhancement is too much.
Yes, I know.
And they have taken back the land.
No, that who will you otherwise, my lord? What has happened? And there are two aspects. Another is that it was not used for operational purpose.
And that was not required also.
That was, but from our exhibits, cross-examination part, it has been established that there was an agreement between all Assam Students Union and it was made an industrial purpose. And that has been
It was a tea garden otherwise.
no, all over this, all land regarding Sipsagar, my lord. The tea garden, irrespective of tea garden or it was made 55,000. Since it was a bilateral examination, it was reduced to 52,000. So actually, the loyalty was not.
Okay. But here the case goes a step further. That without necessity you had done
No,
it.
no,
Without
yeah.
the not there.
Now you're also that part of your lordship from the cross-examination part. I have come to the. I've also exhibited those documents. From the documents, the CISF initiated the proposal that we want storerooms and so there, this Mazenga land was there. Mazenga was 35 acres. They want 250 acres. So that was not possible in Mazenga. So they went to Ligri-Bukuri. Ligri-Bukuri, some plots are not in good condition and some tea leaves are there. So that was
The
Limited, my lord.
evidences and the judgment reveals that this was an unilateral action on behalf of a few persons for giving benefit to the person from whose land is being
but they have
secured.
not made a party, first of all. Either they according to the IO, no evidence against the private party.
Yesterday also I saw a case, just stopped yesterday. Mr. Kamar was arguing.
Yes, ma'am.
The materials which had come on record had clearly pointed to a particular person. There is a provision in CRPC that during the
319.
pendency of 319, you can,
Yes.
you can incorporate.
Court can exercise the power.
But the CBI does not seem to be very interested in. That was a unique case, ma'am.
But here in this case, you'll also find from the cross-examination, the trial court might have put it left out of the cross-examination.
Mr. Kamar is going hammer and tongs. Madam is very soft. So, but the thing is, the main person, maybe she's just she was hoisted there, but projection is everything happened under her control. Maybe false, but the signatures, the documents, but not there.
What case you'll also find cross-examination, put it left out.
What would be the approach of this court in this connection when something like this comes up before
Now the
this court?
question is that whether the theory of conspiracy, madam, has been proven.
It is, otherwise the materials,
No, no,
uh,
because one conspirator has not been charged or he has not faced the trial.
he has not faced the trial.
So that conspiracy theory
Will not be applicable qua that person
Yes.
who has not faced
Yeah.
it. That's the
agreement
general
will
law.
not come, my lord.
That is the general law.
General law. So otherwise illegality regarding PCK Act, that is different.
No, PC Act will not come in here because both are not government
So,
servants.
that's different.
He is recovered by another from in Nagaon, Morrigan somewhere, along with one other person. The allegation is that she had annulled the marriage and then she had married back. He has also come up and that gives 3,000 was granted. Has stayed there. And the, doesn't seem that the wife is interested. Very difficult to go through. I also thought the Kadir's petition should not have been like this. What, submitting annex, then another one, then you go back again.
And all those are unnecessary, not
Necessary.
relevant.
Okay,
The main question is that, Your Lordship, 145 proceeding was there, and I was the petitioner in 145 proceeding, and the respondent was the opposite party. So initially, an attachment order was passed in my favor.
146.
Yes, and that was also came to the revision court.
Revisional court sent back. the
Sent
matter.
back. Then, my lord, on merit, the 145 was disposed of, declaring possession in my favor. So I think, my lord, there is some fault on the part of the ADM, additional administrator, because, my lord, after remand back, I have found from the record, in fact, what is in the session judge order is that violation of principle of natural justice. Because after remand back from the session court, there should be an notice other party.
Now you tell me.
Yes, 555.
Remand was
55.
on an application made by the respondent here.
Um,
Revisional court, the respondent had approached
Divisional court
respondent. You had not gone there.
I also
Then?
appeared.
Then-
I am the respondent in the divisional court.
Okay.
Opposite party.
The order was passed in your presence.
Yes, yes.
Okay, show me the orders. First
Order-
order, second order, third
Yes,
order.
page number 52.
That is the impugned order.
52. 52 is the order of the ADM. That was challenged in the revision court. And
Okay.
impugned order is 55.
52, 52.
55 melody.
No, 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 ADM order.
ADM order 52.
Okay.
Yes, it is important when first. So 52.
What is the date of this order? 9/2.
9 to May I read mine? CR is put up on petition filed by the first party. That is the
Pandita
petitioner.
Gupta.
And
That
those-
is your,
Yes.
you are.
Yes, I have filed the petition for put up. That means that was no date. The date was not. Okay.
Then the respondent hearing goes before the revisional.
Yes, yes.
That is page 55.
55. Very. Page 56, paragraph number 4. From 9 to 18 order. Page 56, below minor. Being agreed by the impugned order 9 to 18, the second division shall defer the present division mainly on the ground that the impugned order was passed violation of legal norms of principle as the respondent has instituted special LG so and so that the learned court below passed the order attachment. So it is equal. Now, on the point, whether the learned court below had committed error illegally in passing the impugned order. I have heard the learned counsel appearing for the both sides. Where is the record so and so? Decision appreciating the evidence.
Okay, we can come to page 58.
58.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10 line.
Record.
Record.
Record
Also
also
revealed.
revealed that thereafter the said case record was received by ADM on 8/12/17 and no notice was given to the second party in respect of the proceeding. The first party, Iwamoto, appeared and the learned ADM without giving any opportunity to the second party.
This is where I was getting confused. Okay.
Yes.
The second party, it relates to the proceedings before the ADM.
Yes.
Okay.
Second party. My lord, second party also, my lord, yes, ADM, he was second party. Yes, my lord, second party has been impugned order. 9 to 12, 18, although the learned counsel for the respondent has pointed out that arbitrated order.
What is the error here? What is the error in the review? Suppose
It may be fixed by the honorable court, my lord, since both parties
But
have.
Mr. M.J. Kadir, learned counsel for the petitioner, also heard Mr. M.H. Borbia, N.H. Borbia, learned counsel, appearing for the respondent. So the petitioner, by way of instituting the present proceeding, has assailed the order dated, judgment dated 3/12/2018, passed by the Court of the Learned Session Judge Kachar in criminal revision petition number 39/2018. Also, the brief, facts in brief requisite for adjudication of the present issue is noticed as under. The petitioner herein had instituted, where is your application leading to this 145 application?
Page number 15, my lord.
15
1/5.
had instituted an application under section 144 CRPC before the District Magistrate Kachar, Silchar. Also, the said matter was taken up for consideration on an application made by the petitioner herein, on 9/2, was taken up for consideration on 9/2/2018, basing on an petition filed by the petitioner herein. A perusal of the order dated 9/2/2018, passed by the District Development Commissioner, Magistrate Kachar, would reveal that the said order was passed without giving any opportunity to the respondent herein to place his stand in the matter before the said authority. Also, being aggrieved, the respondent herein assailed the order dated 9/2/2018 before the Court of the Session Judge Kachar by way of instituting a criminal revision petition, being criminal revision number 39/2018. The learned trial court, the learned session court, upon considering the materials coming on record, held that the order dated 9/2/2018 to be not sustainable, inasmuch as the same was passed without issuing any notice of the proceedings of the same to the petitioner, to the respondent herein, and accordingly proceeded to interfere with the order dated. Accordingly proceeded to interfere with the, proceeded to set aside the order dated 9/2/2018. Also, Mr. M.J. Kadir, Learned Counsel for the petition, fairly submits that earlier, in terms of, in pursuance to orders passed by the learned, who had passed the first order, which led to the institution of the first CR case,
The same, I'll say ADM.
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 The additional district magistrate. Huh? First one, first order is here on
Yes,
record.
First order, not on record, madam. Not on record.
That is again in pursuance to your, this page 15 application.
Basically,
Submits that in pursuance to the application filed by the petitioner hearing under section 144, case number 184 of the 2017 came to be raised before the district magistrate, Kachar, Silchar. So the same was heard, and that order was in your favor.
yes, yes.
First one. And the position of the petitioner here was determined. So thereafter, then who went up before the respondent here assailed the said order before the learned session judge Kachar. In criminal revision number 143 bracketed M/17. So, the said criminal revision petition was disposed of while order dated 6/12/2017. Accordingly, the matter came to be remanded before the learned ADM Kachar. So, a perusal of the materials, Mr. Kadir submits that on the matter being remanded before to the learned ADM Kachar, the records reveal that no notice was issued. Schedule fixing the date of fresh hearing in the matter to the respondent hearing. He fairly submits that the learned session court wide order dated 3/12/2018 in criminal revision, it submits that the order dated 9/2/2018 passed by the district, development commissioner cum magistrate and magistrate Kachar. Submits that a perusal of the order dated 9/2/2018 passed by the district development commissioner and magistrate Kachar would reveal that the second part, that the petitioner, that the respondent hearing was not heard before passing of the said order. So, Mr. Kadir further submits that the learned sessions court, session judge Kachar, by judgment dated 3/12/2018, passed in criminal revision petition number 39/2018, had noticed the fact that the order dated 9/2/18 was passed without affording an opportunity of hearing to the respondent hearing, and had accordingly interfered with the said order. So, in the above premises, he submits that the order passed by the learned session, the judgment dated 3/12/2018, impugned in the present proceedings, passed by the learned session judge, would not mandate any interference by this court. However, he submits that the matter being pending since 2017 before the district magistrate Kachar, Silchar, this court would be pleased to direct the concerned authority to dispose of the petition filed by the petitioner under section 144 CRPC 144 CRPC. After
Convert to 145.
144 it is there. After subsequently converted to 145 plate bracket of Kudima. After hearing both the petitioner as well as the respondent hearing. Also, the said submission of the learned counsel of the petitioner is not objected to by Mr. N.H. Barvia, learned counsel appearing for the respondent. Also, I've heard the learned counsel for the parties and perused the materials available on record. Admittedly, on the matter being remanded back to the court of the learned ADM, Kachar, the respondent number 2 was not issued with the notice of the date fixed for hearing of the application filed by the petitioner hearing in case number 180 for hearing in case number application in case number 184 bracketed M/2017 and the order dated 9/2/2018 was passed ex parte against the respondent hearing. So this court has perused the conclusions drawn by the learned Session Judge Kachar in judgment has perused the judgment dated 3/12/2018 passed by the learned Session Judge Kachar in criminal revision number 39 of 2018 and finds that the same was allowed interfering with the order dated 9/2/2018 only on the ground that the respondent hearing was not given an opportunity of hearing before passing of the said order dated 9/2/2018. Also, in view of the above position, as well as considering the submissions made by by the learned counsel for the petitioner, this court finds that the order dated judgment dated 3/12/2018 passed by the learned Session Judge Kachar in criminal revision number 39 of 2018 would not mandate any interference. The earlier order dated 9/2/2018 having been set aside, the matter would now stand remanded to the
And ADM.
learned additional district magistrate Kachar for a fresh consideration. Also, the learned ADM Kachar shall now fix a date for hearing. No. We'll fix for a date for hearing in case number 184 bracketed M/2017 and issue notices thereof to both the petitioner and the respondent herein. Also, you both are here, you both can go and appear before the ADM. Okay, eto kati dia sun. Also, in view of the above, matter stands remanded to the learned ADM. Also, the respondent and the petitioner and the respondent being the parties to the proceedings in case number 184/2017, they are directed to appear before the learned ADM Kachar on, give me a date,
3rd of December, after 1 month.
3rd of December, okay, on 3/12/2025. Also, on appearance of the party, the learned ADM shall proceed to consider the issues arising in the proceedings of case number 184/2017 instituted by the present petitioner, and after hearing the petitioner herein as well as the respondent hearing, dispose of the same expeditiously in accordance with law. With the above observations and directions, the present revision petition stands disposed of. Yes, what happened? I thought you had some matter. Which one? Oh, I can't. I know him and